You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome back to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And we had an exciting conversation, at least we think it's exciting, conversation last week about, what's going on in Tennessee with our marriage effort, the marriage bill we're going to be putting forward. And then, of course, reference the letter you sent out to the 95 county clerks. And we addressed the issue of the supremacy clause and some other fun things. And I think today we want to sort of continue that conversation and build a little bit further because, we did, prior to sending out those letters, we did submit a petition that is currently before Governor Lee here in our state. And coming up soon, how long ago did we do that?
December 19th. So he has till February 17th.
Okay. So roughly 30 days-ish, somewhere around there. He has left to respond to this petition.
Right. And let me just note, this petition isn't like we just gathered a bunch of names and turned it in. This is a legal proceeding petition type thing. So for listeners.
The declaratory order?
For a petition for a declaratory order. It's sort of a predicate, a first step to filing a lawsuit. You go to the governor first and say, hey, do you want to fix this problem? If not, we'll sue you.
Right.
So people need to appreciate it. It's not just a petition drive at the Kroger or, Walgreens or something. Yeah. But anyway, go ahead. So that petition was filed.
And so what we'll get into a little bit later on in this episode is, the governor is sort of between a rock and a hard place, and he's got to generate a response, and we're going to speculate, as to what his choices are.
Yeah.
But first, before we get to that, just kind of wanted to lay out, David, and talk with you about, not too in depth, but what marriage is, and the fact that, people have been getting married for a long time.
Even before the state of Tennessee existed.
Yeah, go figure. Even before then. Heck, you get on ancestry.com, right? And you can find all sorts of records of marriage. I mean, and before the state was licensing marriage, we had to go back to our church records.
Yeah, that's right.
It was the
family Bible that kept a lot of that information.
Yeah, family Bibles, churches, church records. And so just want to talk briefly about this idea that, marriage did not come from government. And people I think legislators too, and people in general get squeamish when we start talking about messing with marriage licensing, because then the first question is, oh my God, how do you get married?
That's right.
And so we kind of want to lay that groundwork a little bit because that's going to be part of how the governor makes his decision. Part of his decision-making is, well, first off, how does he understand marriage, and how does he see the state's role in marriage?
That's right.
So let's get into that a little bit.
Yeah, we both went last week, and I spoke to a group of pastors, and sometimes when I try to help people think through this question of marriage, I say, how many of y'all have children? And of course, in that group of pastors, they all raised their hands. And I said, now, how many of you are a father only because you got a birth certificate from the state? Well, nobody raised their hand. I said, are you a father whether you got a birth certificate from the state or not? Well, sure. Why are you a father? Well, because I got my wife pregnant, or, I hope they all were wives.
Yeah, right.
And I say, okay, so the government didn't create you a father, or make you a father, or give you a status of a father because they gave you a government form. Well, no, that's crazy. Okay. If the government stopped issuing marriage licenses and said, we're just not going to license marriages anymore. If you get married, we'd like for you to come down here and register it, but we're not going to license it. Would you say, well, people can't get married if you don't give them a license? And the look kind of comes over their eyes.
Yeah, there's a little bit of a pause.
It's like, well, no, for the same reason I'm still a father, whether or not I got a birth certificate or not. I made a promise to my wife. My wife made a promise to me. Minister solemnly charged me before God to take seriously my oath and ask if anybody knows why you shouldn't be married, and speak now, forever hold your peace. And I guess I'm married. Yeah, no, I'm married. Are you married because you got the license? Well, not in God's eyes. I made a commitment. Yeah, that's right. You did. And so one of the things we talked about in our early podcast was the understanding of common law and common law marriage. Common law is the notion that is not enacted by positive actions of legislative bodies, that exist prior to any formal government actions of civil government. And they have the weight of law because we've just recognized the truth of this for so long.
Right.
And so there was this concept of common law marriage. And in fact, the Supreme Court had a case from 1877 where the question was, a couple, I think it was in Michigan, had not gotten a license. They provided licenses, but they didn't say, unlike Tennessee, and this is important, the only way to marry is to get a license. So the couple didn't get a license. And the question was, well, were they married? And one side said, well, no, if you didn't get a license, you're not married. And the Supreme Court said, well, that's crazy. They said the right to marriage is not conferred by the government. People have been marrying forever. All the government does is when you make a promise to your spouse, the state will back it up if you breach it, just like any contract. So no. They didn't have to have a license to be married. You have to find that they, in fact, got married. They made those promises. They made those commitments. They lived like, is there proof that they made that promise? Is there proof they lived like that promise? If so, they're married. Mm-hmm. And the court went on to say the reasons that states require registration and licensing is not to give you the right to marry, but so they know who is married and to provide proof that they're married.
Right, so that they can secure those rights later on and those obligations whenever the need might arise.
Yeah, so when somebody breaches their agreement, Linda can enforce that against me and say, see, we're married. We filed these pieces of paper. You got your name signed on it, and the minister acknowledged that we did it.
And on that point, we've used the analogy quite often that, this is just like buying a house.
That's right.
When you go to buy a house from someone, we don't first go, there's nowhere to go to first get permission to buy a house. We don't need a license.
Permit.
Yeah, we don't need a permit to buy a house.
Yeah, or to sell it.
Yeah, you have a house, I have money, and we want to make a transaction, and I want to buy your house. We as individuals, as people do, we agree to that transaction. And the transaction's done.
That's right. I've done 2 of those.
Yeah. Now once you get the deed, which is just an interaction between 2 individuals.
It's evidence of the contract.
Right. It might be a good idea to go down to the county and file that as a record that you've purchased the house.
That's right. Because otherwise I might sell it to somebody else later in the day or the next day.
Right.
And then they go record it. And when you show up, you say, well, I bought this house yesterday. And they said, well, you didn't put me on notice. You did.
Right.
Tough luck. Go sue Fowler and figure it out. Or let's assume I bought my house from you. I want to record it. So 20 years from now, when you're long gone and living in Lord knows where, I can prove that I own the house. So when I want to sell it, they're not asking, well, where's Gary? So we do this all the time.
Yeah.
But immediately when it's marriage licenses, because we've been doing that so long, we don't think of this analogy to real estate transactions. We become so status that we think, well, if you don't have a license, how do you get married? And so I was on a call last week with a group of pastors, and a lawyer friend of mine who's a very committed Christian person, when that question came up from the pastors, well, if we had a common law marriage understanding of marriage, that marriage is a pre-political right. It doesn't come from the government, and you can go record your marriage and make it public record and all that. Well, how would people get married? And he said, because you would say in your marriage ceremony, by the power vested in me, by the word of God, and maybe by denomination or whatever, I hereby declare you man and wife.
Yeah.
And it's like, oh, yeah, that's right. I'm sounding like you now.
Yeah, it's not my fault.
No, I just got choked up. So we have to understand, and this is what the governor's going to have to first do, is what is marriage? And the difference between sexes is irrelevant to the concept of marriage. Now I've created, by positive law, the enumerated right in the Constitution, in the word liberty, the word marriage. As if the Constitution says no state shall deny anybody life, marriage, liberty, or due process. You see what I'm saying?
Right.
It's almost like they wrote the word liberty means right to marry and other things too. Well, those words aren't in there. That wasn't the understanding of what liberty was. But that's how they created a right to marry, by putting it in the due process clause. Then they had to say, well, because it's created marriage, there's no historical thing as same-sex common law marriage. The right to marry arises out of dignity and autonomy, and therefore sexual differences are unconstitutional. Biological sex is not relevant to what a marriage is. Marriage is about, they actually said, not being lonely in the night and other sorts of things. Yeah.
I can't believe that's actually, you said that and I thought you were joking, but then to realize that that's actually written in a Supreme Court opinion is astounding.
Yeah, it really is. So marriage has nothing to do with the difference between biological sexes and pulling people together, or marriage and procreation, or any of that. The image of God, nothing.
Yeah.
It's just two people who
you deserve not to be lonely.
You deserve not to be lonely and all that, and to have relationships. So that's how they created this right to marry, and then they redefined marriage. And I keep saying this so that maybe it'll drive home to somebody. It was as if they said, well, I've created a right to marry, like there's a right to draw squares. But gosh, I want people to be able to draw triangles, so I'm going to redefine what a square is to include triangles. A square is any 3 or 4-sided shape, so that triangles have as much dignity and autonomy as rectangles. Now, I know people laugh and say that's silly, but by analogy, they couldn't say you have a right to marry, and oh, by the way, marriage is defined between a man and a woman. Well, that wouldn't help a gay couple. So they had to say you have a right to marry, and by the way, we are defining for the purposes of the word liberty. When you pretend to read the word right to marry in there, read right to marry defined without regard to biological sex. Then the court did something interesting. They said, well, if marriage is by definition not a relationship depending on sexual differences, well, you've also violated the Equal Protection Clause. Okay. Now that's important, and I want listeners to understand this. They did not say, well, having sex with whomever you want is a constitutional right. Men and women are androgynous widgets, easily substituted. There is no difference in bodies, biology, temperaments, all the things that might distinguish men from women. All of those are constitutionally irrelevant. Now, let's look at your state law. Well, you're making men and women a criteria when what's the difference between the one Cheerio in your bowl and the other Cheerio in your bowl? I mean, they're just all widgets, right? Then you would violate the Equal Protection Clause. And then you would say, that equal protection violation is so flagrant that it deprives me of liberty. There's just no sense in it. It's just stupid. Everybody knows men and women are androgynously all the same. The court went the opposite way, though, because they couldn't go through equal protection first without saying men and women are constitutionally, legally the same thing. Because once you do that, lots of laws change.
Imagine.
Yeah. All of a sudden, you can go topless at the swimming pool if the man can go topless. The woman can rip off her swim top and And that's happening.
Well, and forget women's rights and all that sort
Sure.
of stuff. I mean, all these conversations we have about unequal pay and all that stuff, and all of that, everything
Sure.
goes out the window at
So,
that point.
and also, if you say bodies don't matter, then what does that do to the transgender athlete issue?
Mm-hmm.
Why are you not letting me compete as a woman because I think I'm a woman because you said bodies don't matter?
Well, I think women in men's sports at that point just completely goes away.
Yeah.
If we're all just the same.
And that's where we're headed.
Yeah.
Except some women are now starting to say, wait a minute, we fought for years to be treated as women,
Mm-hmm.
not women because of our heads or something we feel about ourselves, but because we biologically are women. So the Supreme Court didn't want to go there. So it had to first redefine marriage and then say, well, since marriage by definition, sex is irrelevant, now it is an equal protection issue. I hope people get that. But here's why that you may say, well, what's the difference? The bottom line is Bob and Fred and Susie and Sally are still getting married, whether it's equal protection or due process. Well, it's a huge difference in the law. And that's where the governor has to make a decision. If he says, well, Obergefell was really a due process 14th Amendment liberty case, I've just now said marriage is a matter of federal policy and law, not state law anymore. I just turned marriage and family law and divorce law all over to the federal government because it's federal policy. Or he can say, no. This is still a matter of state law, and it was an equal protection case, to which I'll then look at the governor and say, oh, so you believe that marriage is fundamentally a non-sexed relationship that man and woman.
Just a quick correction for that. When the scenario you were describing there first, which you meant to say due process.
Yeah, due process.
Yeah, if it was a due process instance, then it's a federal.
That's right. If he wants to say no, we still have control of marriage. Marriage is still a state issue. Then you're going to have to say, okay, if marriage is still a state issue,
it's an equal protection case at that point.
It's an equal protection case, and in that case, you're conceding that men and women, there are no differences between them, and we shouldn't have any differences between them. And everybody knows that marriage is defined without regard to sex, and so that's why it violates equal protection. You would never say, again, a law defining squares with four sides is wrong. You'd say that's what it is. So if he wants to say it's a matter of state law, he should say, well, as a matter of state law, marriage is a man and a woman. But if I agree that that's an equal protection issue, I'm now saying, no, marriage is not a man and a woman issue. It's just two people or three or four or I don't know what, two brothers can marry each other as long as they're not going to have children. Why we have an incest law? Well, the governor, I know religiously does not want to say that. So which is he going to do?
Well, and might I say, during his campaign, he clearly said the opposite.
Yeah, he said marriage is between a man and a woman.
Yeah.
God created it that way, and federal judges made a decision they should never have made.
Right.
But they did make a decision. But he has to now decide what was the basis of the decision. Was it really a due process case that had equal protection implications, or was it an equal protection case where the violation of equal protection by treating men and women differently in relationships between a man and a woman and two men and two women differently is so egregious, so fundamentally wrong, it has to also violate due process. Now, that's where he is. Now, the interesting thing is, if he says, I can't sit here and say there are no differences between men and women, and there's a fundamental understanding of marriage such that it's wrong to not let two men and two women marry, he's now got to say, well, then I have to let two people marry because it's a federal law. It's federal policy. Well, now he's got a real problem because the state cannot be commandeered by any branch of the federal government into carrying out federal law. So if he wants to say that, I'll say, fine, Governor, you're right. Marriage is a matter of federal policy. I hate that. The Supreme Court shouldn't have done that, but they did. But then there's nothing wrong in our state constitution that says, I don't want anybody in my state to define marriage as anything other than the historical common law understanding of marriage as a man and a woman. And since it's the federal government's marriage, don't you do it for them. Tell the federal government to figure out how to do it.
Yeah. Yeah, they've created a federal marriage.
They've created a federal marriage.
Yeah.
Now, here's where the real problem comes. If it's a federal marriage, it has to be a federal divorce from a federal marriage, a federal child support case, a federal visitation case, because it's all federal marriage. If you own marriage policy, you own family law policy. And I know the governor doesn't want to say that either, but that's why he's between a rock and a hard place.
And can we just dig into that point for a minute? Because we had part of this discussion last time revolving around the refugee issue and the constitutionality of how the governor responded to that executive order in light of our state law.
Right.
And this issue, to me, is the same thing. And I think no matter where you land on same-sex marriage as a social issue,
right,
I think for most, or should be all, conservatives who value the way that our government is set up, we have and we should have an expectation of the people that we vote in office, whose responsibility it is to administer the laws, to administer them the way that they should be, in the appropriate order and in the appropriate manner, and execute the laws that are on the books until they are changed. And fact of the matter is, again, regarding the marriage issue, we've said this, that the federal government has created a federal marriage. The federal government, like you just said, does not have the ability to commandeer state agents or state agencies to do its bidding.
At their expense.
At the state's expense especially.
Sure.
And furthermore, again, we said the state is not required, and the federal government cannot force the state to license marriages. That is a decision of the state.
Sure.
And our state law that has not been enjoined by any higher court, still on the books today, in force, because it has not been enjoined by a federal court, explicitly states that marriages in the state of Tennessee are between men and women, right, and all other such marriages are void and unenforceable.
So what that amendment says to me, and the Supreme Court did not rule on this question. I mean, that's where, when people make the supremacy clause argument, they're equating opinions with the Constitution, but they're also not realizing that federal courts only decide a particular case or controversy. And they don't decide all the issues that one opinion creates. So it's a fair question. I mean, I've got 60 legal scholars behind me here. It's a fair question. Was Obergefell really an equal protection case, or was it a due process case? We don't really know. They kind of went, "It's an equal protection process case."
Yeah.
Yeah. And which was it? Because it matters.
Well, and I think the court skirted that issue because the ramifications on which one you pick are huge.
Yeah. The court didn't want to make marriage policy at a federal level, really. But they also didn't want to say human beings are constitutionally androgynous, because now all of a sudden, what's the difference between a man's prison and a women's prison?
We've got to rethink every law that we've made.
Yeah, that's right. That's right. So what they were really hoping for, let's just put it down to brass tacks, is that states would not ask these corollary subsidiary questions and would just go ahead and carry out marriage policy to keep everybody happy.
Yep.
And not ask questions and not say, wait a minute, the king has no clothes. The king can't make me carry out federal marriage policy. The king can't make me license marriages. And that very point was raised in the oral argument in front of the court in response to Justice Sotomayor.
This is not a new argument.
No, this is where I got some of this. In reading the transcript of the oral argument, Sotomayor had asked a question about these fundamental rights things, and he says, if the state today decided to have no marriages and no licenses, as some states have proposed, and Alabama just did it. They said, we're not going to license marriages. You just go file a piece of paper.
This is counsel on behalf of the state of Michigan.
Michigan,
in their lawsuit.
Who's defending Tennessee, Michigan law.
Yeah.
He said that wouldn't violate a fundamental right. There's no right to have a license. And then he goes on in the same statement, and he says, the court cannot, as a constitutional matter, force the state into licensing, he says, relationships by forcing them to recognize and give benefits to anybody. That's not the way fundamental rights doctrine works. Fundamental rights are leave me alone, not make the government do this for me.
Right.
And part of the reason that's the case is because the court has no power to make a state or even Congress pass a law. That's why at the end of his dissent, Scalia said something and it bugged me. It just like, what are you telling us? He says, we are the least powerful branch. We have neither force nor will. We don't have will as a legislative body to say this is what we will do. We don't have the force of the executive branch to carry it out. We have only judgment. We decide a particular dispute between particular parties and only that issue, and the decision on that issue may raise a whole host of other issues, which they did. Is marriage now still state law policy or is it federal law policy? They didn't answer that question. They kind of mumbled and stumbled and talked out of both sides of their mouth, and we don't know the answer to that question. It's legitimate to ask the question. Mm-hmm. And so we've got, I lost sort of my train of thought there, but it's legitimate to ask those questions, and it's legitimate to say, oh, I know. What Scalia said was, so all we can do is exercise judgment. I can decide what to do between a same-sex couple from New Jersey who wants Governor Haslam to recognize their marriage. I can say, Governor, recognize their marriage. But he says, but we depend on the executive branch, the president, mm-hmm. and the states to give efficacy to our judgments. In other words, somebody's got to carry them out. I can't put the whole United States and the whole General Assembly and every state and local official in jail for contempt of court. And he said, so someday, as we continue to take rights away from the people that belong to them, we will be reminded of our impotency. That I can't make you pass a law. I can't make you carry out my judgments. So if you read Obergefell, you can read it till the day you die, and you will never find out how they said you're supposed to exercise your right to marry. How do you do it? So it's the same question to them that minister asked. Well, if we get rid of licenses, how do you marry? Well, you get married in the eyes of God. You get married between yourself, you and your totem pole or whatever it is. That's how you get married. And then you go down here and let me know you did it. And so Scalia was saying, we can give you a right to marry, but we can't tell you how you go about doing it. Because if you want a license to marry, somebody has to enact a legislation to create the license and authorize somebody to do it.
Right. And the court can't do that.
And the court can't do that. Now, let's go back to the refugee situation, because we got a lot of positive comment on saying, I never thought about the federalism issue. I just looked at the issues of, the safety, the ability to vet the refugees and not be bringing in terrorists. I looked at care for the poor and the fleeing from persecution and all that. And that's all great. And I'm not going to beef with the governor on that. Yeah. I don't.
And of course, financial implications and all who pays for it, all that sort of stuff.
But the question was, can Congress empower the governor to make essentially a policy decision for the state of Tennessee?
Yeah.
The answer is no, they cannot.
Right.
Because the Tennessee Constitution says who makes policy decisions. And the Constitution says the governor doesn't make policy decisions. The legislature does, and he carries them out. So when Congress starts trying to say, you can decide this, they have no power to do that. Now, that doesn't mean that the legislature couldn't authorize the governor to do it. But he can't just do it on his own because Congress said he could. So let me give you an example. This is where everybody would jump up and down and say, David, you're nuts. If Congress had said, well, we're going to allow y'all to have refugees in Tennessee, but we want to hear from David Fowler, would everybody look at me and say, what in the heck were you thinking, Congress? Who's David Fowler? What? He's not even a government official. You'd say, you don't have any authority to do that. You're not even in the government.
But in the way this situation was handled, they would have said, oh, cool, David. Okay, well, David, what's your decision?
Yeah, what's your decision? Yeah, so that's all I'm fussing
about. It's ridiculous.
Yeah. And I get that the governor leads a businessman. He's not used to thinking through these kinds of issues. In fact, the legislature's not used to it. We've become so subservient to the federal government. They tell us to, cut our nose off. We'd say, well, how deep do I have to cut it off? I hate to say it, but that's what the federal government said to do something, so we did. Now, fortunately, on the refugee thing, they sued and said, wait a minute, you're forcing costs down on my state. But that's why you're correct. Marriage is the same thing. If marriage is now federal policy, I could carry it out for you, but I don't have to.
Right.
You can't make me, and I'm not going to do it at my expense.
Right.
You want me to issue licenses and you want me to handle all your divorces? Send me the money.
So that's a huge point, that the continuation of carrying out the Obergefell decision is strictly dependent on a state's leadership being weak enough to just be subservient, be submissive, dismiss their own laws, their own state constitution, and just do the bidding of the federal government without question.
Exactly.
I mean, who wants to be there, left or right? I mean, honestly, if you really boil it down.
Well, the left does at some point.
Because they believe in globalism and statism and all that sort of stuff.
Well, they can get the Supreme Court to do what they want.
Yeah.
And then if we just willy-nilly obey them, that goes back to the Supremacy Clause issue.
No one who values liberty wants this, no matter where you fall on this issue socially. If we understand the implications of continuing, like you said, to acquiesce to these types of judgments from the court, or like you said, even if it's from Congress. I mean, Congress can't give authority to a governor to do something that his state constitution doesn't give him the authority to do.
Right.
These things are important.
Right. So now here's the governor. He says, gosh, David, I mean, I'm sure he's not listening to our podcast, but maybe some of his friends are. You're right. I don't want to acquiesce to the federal government and turn over federal marriage policy to them. That's not a conservative position. So I'm going to take the position that marriage is a matter of state law. Okay, good. State law now controls the issue of marriage. You've just conceded that, right? Yes, that's right, because I hate the idea that I've turned it all over the federal
government. Which is
the
right call.
Which would be the right call.
Yep.
Except that now the question is, state law says that I don't want anybody in my government to license a marriage if it's defined that way. Because the only thing we have is the historical understanding of marriage that's a legal contract between a man and a woman. Now, you just said, Governor, that's a matter of state law, and that's the supreme law of the state of Tennessee. Now, he can sit here and say, well, but that violates equal protection because men and women are androgynous, and we should have never said that. Well, you don't believe that. You don't believe they're androgynous. I know that. You've said that. I know you. I know too many people who know you. You do not believe that men and women are interchangeable widgets. And so...
And by the way, you were elected on that assumption.
Well, on many of those same assumptions. But here's the point. There's nothing that prohibits the state people, the people who are the supreme power over the state expressed through their Constitution, from saying, well, if that's what the Equal Protection Clause requires, we're not going to do that. We're not going to license those marriages. And we've told you that. The Constitution says any policy by your administration, law by the legislature, or judicial interpretation by the state interpretation that purports to define marriage as anything other than a man and a woman is void and unenforceable. And then the governor would say, well, David, you just ran us into a dead end. I mean, what are we going to do? I can't uphold the Tennessee Constitution. I don't want to admit what I don't believe is true, but I can't license a marriage. How are people going to get married? And I'll say, are you the father of your children because you got a birth certificate or because you fathered them? Well, I fathered them. Well, are you married only because you got permission from the government, or and you're saying now without a license, no man and woman in Tennessee can ever marry again. They can't enter into a marital relationship. It's just marriage doesn't exist in Tennessee. Well, no, I don't want to say that. Fine, then vote for our bill. And our bill, the Marital Contract at Common Law Recording Act, complies with Obergefell. Why? because it's not civil government enacted marriage right to marry.
Yeah, it doesn't license.
It doesn't license anything.
It just recognizes our right to marry.
It recognizes the common law right to marry, which happens to be what's in our Constitution. So you're complying with the Constitution when you say if a man and a woman in this historical situation get married and they want to record proof of their marriage, they can do so. But it only a man and a woman, because that's all state law allows me, and you said this is state law. And federal law, you said, left the definition of marriage and the handling of marriage up to the states within the limits of the Equal Protection Clause. But since I'm not licensing anything, I'm not violating the Equal Protection Clause. And the Supreme Court didn't address this other understanding of marriage as a pre-political common law institution. They, in fact, said, we're not talking about that yet. So therefore, until the Supreme Court says it's not constitutional, it's constitutional.
Right. Yeah, again, they explicitly stated we're not dealing with this common law understanding of marriage. We know it exists, but we're only dealing with the enacted law.
Yeah, and the point early in the thing was we even have cases that acknowledge this.
Yeah.
But we don't want to talk about that kind.
Yeah.
And partly I think they don't want to talk about that kind because they know states don't like that kind. It seems too loosey-goosey. It seems too much like shacking up.
Yeah.
So they just thought, you'll keep carrying out your license policy. Ha! And everybody bought it. I mean, even the dissenting judges said states are required to issue same-sex marriage licenses. Well, maybe I am required to issue a license to a same-sex couple, but I'm not required to issue a license. That's right.
Yeah.
I am allowed to let people marry and provide proof of their marriage. And when you say, David, that's a crazy idea, that could never work. It's just inconceivable. I'll say, well, we do it every day.
It's worked for millennia.
Well, what people marrying, but the recording of deeds. I mean, we worked out a whole system of that.
Yeah.
So, David and Linda go record the proof of their marriage down at the courthouse. If David ever wants to run off with his secretary and leave his wife and child behind and says we never married, well, David, there's your piece of paper signed that you got married.
Well, and to say, on the whole, I mean, relatively speaking, it was 2020. We've only been licensing marriages really to a great degree in every state across the country for roughly 100 years.
Yeah.
So even in our short American history, there was a long time that we existed as a country, that we had families and marriages, and before any state ever licensed the marriage.
Yeah. People have been married, I'd say since the first chapter of Genesis, so to speak, or the second chapter, or whatever it is. But that's the important point. And so the governor's between a rock and a hard place, and I'm sorry that he's in that position, and our petition put him there, but really the Supreme Court did, and really the Governor Haslam did, because Governor Haslam abdicated and said, just change all the forms and let's just move on. Let's treat everything like the law got changed by the Supreme Court. The words male and female aren't in our law anymore. Just ignore them. He had no authority to do that. He's not a judge. He can't say ignore the law. He can't amend the law. He's not the legislative branch. So he said to the governor, are you going to keep acting as unconstitutionally as Haslam did, or are you going to say, I have no authority to do this? And he knows. I've met with him face to face. It's a tough decision. I'd rather not put him in that place. But my obligation is to defend the Constitution as a citizen. My obligation as a Christian is to defend God's design for marriage. And if that puts the governor in a tough spot and the legislature in a tough spot, I'm sorry.
Well,
we've talked too long probably, but I hope it's been helpful.
Governor Lee, we respect your position that you're in, and we're praying for you.
Amen. We'll leave it at that.
As brothers in Christ, we're praying for you.
Amen.
Hey, as always, we love your feedback and your comments. So you can always email us at info@factn.org. It's FACTN.org. All right. See you next time.
See you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's factennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.